As often happens, it's the lay politician that has to call the tune on negotiations, and therefore I'm genuinely very pleased to be here at this Cambridge conference, and I can only pay tribute to the foresight you had over a quarter of a century ago in recognising the importance that privacy would play in political debate at this time. I think we can say that you've anticipated the zeitgeist in a quite remarkable way. We all know that we're at one of those pivotal moments where the decisions made in the next year will significantly shape the data protection landscape for possibly the next quarter of a century to come. And the question, therefore, is how will history reflect on the work we're doing now? Will we have a data protection framework in place which it successfully anticipated technological and sociological and societal developments, possibly things that are beyond even the wildest imagination at the moment in time? The discussions being held here this year are more relevant than they've ever been. I'm therefore very pleased to be able to contribute to the ongoing debate on data protection. And could I thank the other speakers who have travelled from around the world to be here during this three-day conference. Ministers and governments need all the help they can get in getting the balance right. I might even add, and commissioners do as well. We need to be able to balance the legitimate concerns of the individual citizen that their data will not be abused either by agencies of the state or by private companies. Yet at the same time, we mustn't strangle at birth the enormous potential of the digital economy by over-regulation and stultifying bureaucracy. These are big issues, big decisions. And what better place to discuss these issues than Cambridge? We all know that this is one of the global centres of high-tech business and has emerged as a key enterprise hub that helps to enhance our digital economy. We can be very proud that we have our own version of California's Silicon Valley right here in Silicon Fen. It is therefore important that business here, as well as right across Europe, are given the opportunity to innovate and prosper. The subject which will be of greatest interest to all of you is the EU Data Protection Framework, and I would be interested in hearing further how the proposed regulation should balance data protection rights with enterprise. We all know that this is one of the biggest dossiers ever to be negotiated in Brussels. We're also aware of the headlines, the right to be forgotten, the 2% global turnover fines, and the 4,000 amendments deposited in the European Parliament, for example. Even the tent set up in the working group meeting in Brussels by one of the national delegations has made news. I'm sure that the tent was a symbol of the commitment of the Council of the European Union to work towards getting the right result. Or maybe it was just a sign of the lack of accommodation in Brussels. Either way, I should highlight the immense amount of work that participants in the EU negotiations are put into trying to get the proposed regulations right over the last 18 months. And I know, and I'm extremely grateful to my own team of negotiators for the positive input they've made into those negotiations. And with Seamus here, it is also opportune for me to pay tribute to the Irish presidency for the effort that they made during this presidency. I'm very grateful to Seamus and his team for their efforts in driving this work forward since the beginning of this year. Fundamental questions do remain about the proposed regulation, though. So I think it was right for the Irish presidency to conclude that while significant progress had been made, it is also important for the negotiators to focus on the quality of the text before general political agreement can be reached. Otherwise, we risk ending up with a regulation that promises more than it delivers and may hinder growth and innovation in the digital economy, which we know will be a key driver for continued growth and prosperity for years to come. As I've said, how we achieve a balance between growth and data protection rights is the key question that we're working towards resolving at the moment. We certainly agree with the European Commission and European parliamentarians, as well as other EU member states, in that the new data protection framework should serve a dual purpose, that it should provide for the right that everyone has to the protection of personal data concerning him or her, whilst allowing for the free flow of data, which is crucial to underpinning the enterprise culture. These objectives, however, should be achieved in tandem, not one at the expense of the other. So how do we go about achieving that balance? We've already seen during the 18 months since the draft regulation was published that there has been a tangible shift in perception as to what the best approach would be to balancing individual data protection rights against the obligations of controllers. When the Commission first published the regulation, many concerns were raised about the prescriptiveness of that text, that one size does not necessarily fit all, and that the burdens placed on data controllers and, of course, our regulators may not always be proportionate to the protection conferred on data subjects. I travelled to Strasbourg in May to meet some of the key MEPs involved in negotiations, and it's fair to say that there was a consensus among the MEPs I met that a balance needed to be struck between rights and obligations. In particular, we discussed the importance of not placing disproportionate burdens on small and medium-sized enterprises, which form the backbone of the European economy. Indeed, these SMEs are particularly well suited to taking advantage of the opportunities that technological development will provide. We want to encourage more silicon fens to emerge, not nip them in the bud, and force innovative enterprise to look outside the EU to better realise their ambitions. Bearing this in mind, the emergence of the risk-based approach has been a welcome development during the course of negotiations, and this has been a key element of the work that is being carried forward by the Irish presidency. We have even seen that the European Commission has accepted that there is a place for the risk-based approach, and it would appear that the previous suggestion to place an exemption only around companies employing less than 250 people has fallen out of favour. This, to us, is a sensible direction of travel. The context of processing and the risk of harm to individuals have to be at the forefront of controllers' minds when deciding what safeguards they should put in place.